Hello, welcome to the 15th session for Arbitration Bootcamp, which I started in 2022. I can't believe we're at session 15, and I have to admit that I'm starting to run out of ideas, although every time I say that, I manage to come up with an idea. So if you have any, please don't feel shy about sending them along. You can catch up on my past webinars, which have been recorded and posted on YouTube. After this session, you'll get a recording of it, and you'll also get a list of my previous webinars. So if you are interested in choosing a topic from that list and looking at it on YouTube, it's there for you to do so. The purpose of these webinars is to give you some practical insights, some practical advice, some practical tools on a lot of the arbitration concepts that we hear about all the time on a theoretical basis. And I think and hope they will be helpful to your practice, whether you are counsel or an arbitrator. If you haven't joined before, I promise I will have you out within an hour. I generally talk for about half an hour, 45 minutes. You'll see I've got the Q&A box open. If you've got any questions, feel free to send them to me during my remarks. And if I don't see your box, I will be sure to check your question. I will be sure to check before I finish my remarks and answer your question then. If you're tuning in for the first time, I am a partner at Lerners and a roster arbitrator at Arbitration Place. And I am also the editor of Arbitration Matters, which I hope most of you know about at www.arbitrationmatters.com, which is a newsletter and website in which I post summaries and commentary on cases as they're released from courts across Canada. In some cases, I have some writers who like to talk about international cases that have some relevance or impact on Canadian case law. So please do check that out. But the topic for today is something that I actually think is quite interesting, in part because it seems to be getting a lot of traction and buzz lately, and that's Med-Arbs, or you may call them Med-Arbs, and I'm not sure we're going to actually solve that issue today. But what I'm going to cover is, what is a Med-Arb? There are some misconceptions and questions about that, and how can you use a Med-Arb as a tool for dispute resolution, particularly if you're an arbitrator and you don't know much about this tool. There are traps for the inexperienced, both arbitrators and counsel, and of course the biggest trap can lead you to a concern that the award that may be rendered could be set aside on grounds of procedural unfairness. So there needs to be a structure and process in place which deals with that and protects the parties, the ultimate award, the settlement, and the arbitrator. And of course, the role of the arbitrator or the mediator in Med-Arbs, that is the same person, is very important because that role changes throughout the process. I'm excited about part two. This is part one, where I talk generally about Med-Arbs. But part two is going to involve an interview of David McCutcheon, who is a very experienced and well-known mediator and arbitrator who does a lot of Med-Arbs and can provide some guidance on best practices. I am going to interview him. That's on April the 8th. And I've got some questions already lined up. I will circulate to those who register in advance a copy of his standard form terms of reference. So you've got those both as a precedent, but they may also allow you to think of some questions for David. And so we can have an interactive Q&A if you like. And as I say, I'm quite excited about that because I have a lot of questions for him about the process. And I've seen his standard terms of reference, and they are very extensive, and they deal with some of the issues that I raise today about some of the structures and protections that need to be in place to protect the process. So firstly, what is Med-Arb? Because it is to be distinguished from some of the other processes, the ADR processes that we're all familiar with. So it is a single dispute resolution process that has two parts. It starts with a mediation And to the extent that some of the issues or none of the issues are resolved through mediation, proceeds to an arbitration stage. And it can work if some issues are resolved through the mediation process. So it needn't be a situation in which nothing is resolved. There can be a productive mediation process in which some issues are resolved through mediation and some of them go on to the arbitration process. And there's real value in having the same person do the mediation and the arbitration. But if we start from first principles, anybody who's interested in proceeding with this kind of process must be satisfied that Med-Arbs are permitted in the seat of the arbitration. So I'm just going to say a few things about the Canadian arbitration legislation, which provides for a Med-Arb process, but the legislation does so in different ways. So, for example, in the Ontario Arbitration Act, the Section 35 says that an arbitrator may not conduct any part of a mediation or process that might compromise or be seen to compromise the tribunal's impartiality, but so you read Section 35 and your first reaction is, well, Med-Arbs cannot take place where the seat of the arbitration is Ontario. However, Section 3 is a general section within the Arbitration Act that indicates that parties can opt out of or waive certain provisions of the Arbitration Act, and this is one of them. And there are a limited number of provisions in the Act that actually cannot be waived by the parties, and those relate to things like procedural fairness, which is not the subject of today's talk, of course. So under the Ontario Arbitration Act, it is possible to have a Med-Arb process where the parties consent. Under the domestic acts of Alberta, Saskatchewan, Manitoba, New Brunswick, the arbitrator can act as a mediator if the parties consent, and after that resume the role of the arbitrator. So the language in these acts takes a different approach, and specifically positively allows the mediator to take the role of an arbitrator later on. In BC, under the new Domestic Act, Section 47, the approach again is a little different, but the Med-Arb process is permitted. It says that it is not incompatible with an arbitration agreement for the tribunal to encourage settlement and you actually use mediation and conciliation. So those provincial domestic acts specifically allow for a Med-Arb process. In Quebec, which generally is a much more pro-arbitration regime, there is discussion about the duty of the arbitrator to consider mediation, and the arbitrator may attempt conciliation if the parties request it, and continue to arbitrate if the conciliation fails. Under the international acts, first thing to know is that the model law is silent on that subject. So if the parties agree, there's nothing in the model law which prohibits Med-Arb. It is specifically permitted in the Alberta International Commercial Arbitration Act, which says under Section 5, the same person may be a mediator and arbitrator. So the overall point is that in Canada, Med-Arb may be used. So I've talked about what Med-Arb is. What isn't Med-Arb? Because there are several related concepts. Med-Arb is not a process that we sometimes see in either multi-tier or stepped, as we sometimes call it, arbitration clauses. And those are clauses which provide for some kind of a negotiation or mediation process before the arbitration. And that invariably involves a negotiation among, for example, senior officers of the corporations who have a dispute in relation to their agreement, and in respect of which there is an arbitration clause which provides for conciliation, negotiation, or mediation before arbitration. And that leads, of course, to the issue that I've dealt with in a previous arbitration bootcamp session about whether mediation or negotiation is a required step before arbitration may be proceed. And that, of course, is an issue that's to be determined based upon an interpretation of the language of the arbitration agreement, but it raises the issues of what we call jurisdiction versus admissibility. And if you're interested in that topic, I have dealt with that in, I think it's my session number 7, and you can get more information about that because it does give rise to some limitation period issues. And because the right to arbitrate arises based on the language of the parties' agreement, it's necessary to take a look at whether arbitration is optional after this negotiation portion or whether it's required, because some of those clauses provide that a party may request that an issue a dispute be determined by either court proceedings or arbitration. So this is not Med-Arb. So what are the pros and the cons of Med-Arb? It is, as I say, one process, 2 stages, and that in itself, I think, gives you an idea of some of certainly the pros. It allows for greater speed and efficiency. And this is in part because parties have input into the outcome at the mediation stage. So they have committed to a process in which the first stage is mediation, the second stage is arbitration, and they realize that after the mediation, if they don't resolve their issues, they will be putting their dispute in the hands of a third party. And many litigants find that intimidating and not obviously ideal. And they like the idea of having control, which provides an incentive for the mediation to be a constructive process. It also provides to the parties a guarantee of finality, which is something they usually want in arbitration, but it combines this sense of they've got input, they've got participation into the outcome, and yet they know that the process will end. We all have been involved in mediations which have gone on sometimes beyond the date of the mediation, and despite the parties' interest in resolving their issues consensually, it just can't be done. Med-Arb provides parties with an end date, particularly when at the very beginning of the process, there is a schedule set out for the mediation process and the arbitration process. There is a timeline after which the parties know that there will be a resolution. The speed and efficiency benefit also means that there is flexibility in scheduling and timeline in actually process. That is a real benefit to Med-Arb, and it's one of the benefits that we see also in arbitration. It helps build the momentum when the parties start out in a mediation process that they know will carry through into an arbitration if they don't resolve their differences. It creates momentum and an investment in the process. Another benefit of Med-Arb is costs. The parties are paying for the time of one professional, and that means that one professional has a learning curve with respect to the issues, the legal issues, and the other issues in the arbitration. It's not necessary to leave that professional behind and start afresh with a new professional in the way of an arbitrator. This single decision maker really helps this professional become very familiar with the issues. We've all had an experience as counsel in which we have promoted our case to the decision maker, knowing that there's all sorts of background that the arbitrator doesn't know and frankly needn't know to resolve the legal issues. But sometimes context is important. And when you have the process start with a mediation, the arbitrator, if that process leads to arbitration, has a much greater understanding of the parties' interests, not just their legal rights. Now, I'll talk in a moment about the limited ability for the arbitrator to use some of the information that's been obtained in the mediation. But overall, the views of the parties and the separate interests that they may have separate and apart from their legal rights and obligations can sometimes be very useful for an arbitrator to understand why are the parties here and what do they need in order to get a satisfactory order at the end of the day. The process then develops from mediation through to arbitration, and the parties don't feel like they're starting at square one and moving forward once the arbitration starts. It also allows for creative dispute resolution design. This is something I've talked about repeatedly in my sessions about one of the benefits of having an arbitration as opposed to a court process is that a process can be customized for the dispute. And that is certainly the case in a Med-Arb process where the mediator who may later turn into the arbitrator can work with the parties on what is the best process to get this dispute resolved. And that may be dealing with things on an issue by issue basis. If some of the larger issues are resolved up front, it may be much easier to resolve the smaller issues. And in fact, there may not need to be a determination or adjudication of the smaller issues. So some of the issues may be narrowed in the mediation, which leads to a much more efficient arbitration. And it may be that having the arbitrator and mediator being the same person makes things easier to settle, although that's not always the case. So let's go to the cons of Med-Arb. The fact that there's a mediation process first before arbitration can be used strategically by a party for delay purposes. There's no doubt that that is a strategic decision made by some parties in a dispute. That also makes it important to appreciate the significance and importance of a timetable that comes out at the very beginning so that parties know when and how the ending will occur. And of course, if the parties' mediation is productive and constructive, there can be an amendment to that timetable. But if it isn't, the party can go on, the dispute gets then moved on to arbitration. Another con, and this is a very significant one, and it's one that you may well have heard from clients or you may yourself share this concern, and that is it may be hard for parties, unrepresented parties in particular, and unsophisticated parties when it comes to arbitration, may have difficulty buying into the process because they may feel that it's difficult to start with a mediation where they are uncomfortable about disclosing certain things, knowing that the mediator will later be the arbitrator of that dispute. And so this is a really important factor that the professional needs to take into account when designing the process. And I'm going to talk a little bit more about that, but that makes the terms of reference of the mediator arbitrator extremely important, which is why I think you'll find taking a look at David McCutcheon's terms of reference really helpful to kind of do more than kind of conceptualize some of these issues, but actually show you a roadmap to how to get there so that you can satisfy yourself and your clients that this is a process that's constructive and that there are protections built in to make sure that the arbitrator uses only limited information during the arbitration and makes the parties more comfortable in what they choose to disclose during the mediation. Another con may be that if the parties agree to a Med-Arb process at the very beginning when they are drafting their agreement, their arbitration agreement, there may be, as a result of changes in their interests, less commitment on the part of one party or perhaps both to the mediation process, and that can stall things and drag them down. There may also be cons in having a single decision maker. So there may be concerns about the arbitrators, in particular, duty of independence and impartiality. Will the mediator come to certain conclusions which will affect the outcome of the arbitration during the mediation process? So there are clearly potential implications to reasonable apprehension of bias issues. Those are exacerbated by the possibility that the mediator will do an evaluative type mediation. And there are some concerns about that, and there may be mediators who choose not to do that. But one significant issue is that it's very common in mediations for the arbitrator to meet with each party separately, which is something that never happens in arbitration. It is improper for arbitrators to meet with parties on an ex-parte basis. So there needs to be, again, a structure and rules to protect the process that will inevitably require the mediator to speak to parties separately. And of course, the concern that parties will have is with respect to confidential information that's disclosed to the mediator during the mediation process, will the arbitrator understand about the fact that that information is not to be used in the arbitration. Another con about Med-Arb is this difficulty in delineating the clear distinction that must be made between the mediation process and the arbitration process. There must be a clear line drawn between those two processes. And I've explained one of the reasons for that, which is that as soon as the arbitrator puts on the arbitration hat, the role is very different, and there will be no side conversations with any party. So again, that must be built into the terms of reference, so every party understands when the mediation part of the process ends and when the arbitration process begins. So it's absolutely critical when you or your client consider this process that you really buy into the whole process and understand fully the pros and the cons, and have terms of reference with the mediator arbitrator that give you the comfort that these protections are there and that they will be enforced. So what are some of the key issues that many people who are considering this kind of process think about? One of them is what kind of materials will be available in the mediation process, and whether that information, documents, for example, then get used in the arbitration. So one of the questions is, will the parties be making full legal briefs at the mediation process with legal argument, with evidence, with documents, or will it be a little less informal? And obviously that's not an issue that you can decide in the abstract, but it's absolutely essential that parties decide at the very beginning what information will be available in the mediation. We all have a sense of the kind of documents, evidence, etc., that will be available in an arbitration because it's a familiar process to us. But is it necessary to have all of that information up front in the mediation? That will depend. And it may be that some information is available at the mediation, and that if the matter proceeds to arbitration, there will still be necessary for, expert reports or viva voce evidence, etc. What should the arbitration agreement look like if the parties decide up front that they're going to have a Med-Arb, if the parties have a dispute and this is something they want to put in their contract? And often these things occur only after the dispute. It's rare that parties in their contract will propose a Med-Arb process. Another big issue is how to choose or appoint a mediator arbitrator. There are actually a relatively small number of professionals that have this expertise, and it really is important to ask around. And there are some of them who are advertised on the various rosters on the websites, but you really do want to have someone who has the experience, even if they are well-known arbitrators or mediators, and perhaps even both. If they haven't actually done a Med-Arb process, you really need to consider whether there are at least precedents you can use and to kind of guide you in that process. Because as I hope I've instilled upon you now, the process is absolutely essential. And by having a mediation followed by an arbitration and conducting those processes independently does not necessarily achieve the result that parties want, and may leave them open to risk that the ultimate award may be set aside. So that takes me to my next issue, which is whether Med-Arb processes are more vulnerable to challenge. So for example, if they're more vulnerable to an application for set-aside on the basis of an unfair process, or a challenge to the mediator arbitrator on the basis of a reasonable apprehension of bias as a result of either information that's been provided during the mediation process or the way in which the mediation has been conducted. And the Med-Arb agreement must deal with all of those issues. So some of the things that are dealt with in these agreements are standard. The mediator or arbitrator must have the same immunity as a judge of a provincial superior court. You see those in very standard terms in an agreement. The mediator or arbitrator may not be called as a witness in later proceedings, again, standard. No party will introduce evidence of comments, views of the mediator or arbitrator made during the mediation process in any subsequent proceeding. The documents put forward in the mediation cannot be used in the arbitration unless the parties consent, which goes back to my question about what information is made available in the mediation and what decisions should be made about what information will later become evidence in the arbitration. And it's a term you see quite frequently in Med-Arb agreements that no party can end the process. No party can simply walk away. A party can withdraw from the mediation at any time, but the matter proceeds to arbitration, and the party who is withdrawn from the mediation will presumably participate in the arbitration. But there are all sorts of rules, which I've talked about in previous sessions, about what happens when you have a party which decides not to participate in the arbitration. This is an important protection because it means that the parties get invested in the process and one party just simply can't walk away from it. Which brings me to the process, which I've talked about a couple of times in these remarks. How do you structure a process that has the protections you're looking for, the structure that you need? The ADRIC mediation arbitration rules is the answer. And they're the only detailed rules that I know of, and they specifically address this process. There are ADRIC arbitration rules, which apply during the arbitration process stage of the process, and there are ADRIC mediation rules that apply during the mediation part of the process. So the Med-Arb rules speak directly to all of the procedural protections that you need to have when you are engaged in an Arb-Med process, Med-Arb process. Here are the key features. There is a standard dispute resolution clause specifically for a Med-Arb process. All disputes arising out of or in connection with this agreement or in respect of any legal relationship or associated or derived from this agreement will finally be resolved by Med-Arb under the Med-Arb rules of the ADR Institute of Canada. The seat of the arbitration shall be X, the language of the arbitration shall be Y. And this language, it is very simple, can be contained in the parties' arbitration clause in their business agreement, but it's more common that you find it in a post-dispute arbitration agreement, which is a referral to arbitration type clause. Very simple. And the benefit of doing that is you don't need to include or recreate a process that you think provides protection when there are standard rules here that are tried and true. The rules are very important in that they provide that unless the parties agree, ADRIC will appoint the mediator or arbitrator. So we go back to my point that it's sometimes very difficult to find someone who has that expertise. ADRIC will have people who have that experience. And the appointment process is very similar to that which you see in the mediation rules and the arbitration rules, which is that ADRIC will deliver a list of a certain number of candidates which the parties have the ability to count on, to comment on, strike, etc. If the parties ultimately cannot reach agreement on one of those names, then ADRIC will make an appointment from somebody not on any of the lists. The rules provide for independence and impartiality. Absolutely critical if you've been watching my webinars. Independence, as I've said before, refers to the relationship that the arbitrator has with the parties, the counsel, or perhaps the issues in dispute. Unless the parties agree otherwise, they can waive or consent to some of these issues that raise concerns about independence. We would call them conflicts. In our business, there are certain conflicts which parties may waive and certain conflicts which they may not. And if this is starting to ring a bell, it's because I've talked about this, and the IBA rules on conflicts of interest in international arbitration are a very good resource for checking out the kinds of conflicts that may be waivable and those that are just too close that the parties cannot and should not waive. So the first independence requirement says the arbitrator and mediator shall be independent unless the parties agree otherwise. And there may be very good reasons why parties agree to waive those kinds of issues in order to obtain the arbitrator mediator that they're looking for. And impartiality, another requirement under the Med-Arb rules, relates to the arbitrator's actions, the obligation to treat the parties fairly and equally. And this cannot be waived by the parties. So there is at all times a requirement that the mediator and the arbitrator treat all parties fairly and equally and provide a fair and equal process. The remedy, if that is not complied with, is, of course, a set aside of the ultimate arbitrator award. So I'm now going to just actually read from the Med-Arb rules because I think they're actually really helpful on this point. So the mediator or arbitrator must remain independent unless the parties agree otherwise. I've said that. Remain impartial and not advocate for any party. That is a requirement that cannot be waived by the parties. And even in the mediation process, the arbitrator cannot advocate for any party. And must sign and deliver a written statement to the parties on or before accepting appointment as a mediator or arbitrator, stating that they know of no circumstances likely to give rise to justifiable doubts about their independence or impartiality, and will disclose to the parties any such circumstances that arise after the appointment and before the Med-Arb concludes. So this is something that you will have heard me talk about in the arbitration context. The arbitrator has a positive duty, the mediator arbitrator has a positive duty at the outset of the process to disclose any potential conflicts, and that obligation continues throughout the entire process. So if at any time the Med-Arb mediator or arbitrator thinks that, for example, any information that has been disclosed during the course of the mediation no longer allows the mediator or arbitrator to feel comfortable that they can deliver on this impartiality obligation, then the mediator or arbitrator will resign. And that also means that the parties at any point along this process can challenge the mediator or arbitrator. Now, because of the protections that are included in the process, which I'm still going to get to, that should be a relatively rare occurrence. The arbitration/mediation agreement should also specifically state when the mediation phase ends and the arbitration phase begins. I've said that a couple of times because it's absolutely critical that the parties understand the difference, and it will require the parties to sign additional documentation to acknowledge that they understand where in the process they are, and that is something that protects both the process and the parties. So here's what the Med-Arb rules say about that. The mediation phase ends and the arbitration phase begins when the first of these occurs. Any agreed to time limit for the mediation phase expires. The parties settle all disputed issues. The parties agree in writing to end the mediation phase. The mediator arbitrator declares that continuing the mediation phase is unlikely to settle further issues, or the mediator or arbitrator declares it is appropriate to move the issues to the arbitration phase. When the mediation phase ends, the parties must confirm which issues have been resolved and which will be included in a settlement agreement or consent award, must identify the resolved issues for the arbitration phase by the mediator or arbitrator's deadline, or the mediator or arbitrator will identify the issues if the parties cannot agree, and consent, and this is really critical, consent to continuing with the Med arbitrator, and this is the Quebec Code of Civil Procedure requirement under under Article 620, but I think it seems like good practice in any Med-Arb process. And what this ensures is that there is a clear understanding, which has been recorded in writing by the parties, that the rules are now shifting, and a protection against a later challenge to the award. The rules go further. At the beginning of the arbitration phase, so I've just told you what happens at the end of the mediation phase. At the beginning of the arbitration phase, the med-arbitrator must decide any challenge to the med-arbitrator based on the mediation phase before continuing with the arbitration. So this requires a party that wants to challenge the med-arbitrator for bias, for example, must do so before the arbitration phase starts. Again, that protects the arbitration process. Any party that does not object waives any challenge to the med-arbitrator based on the mediation phase. And any other objection to the med-arbitrator must be resolved under the ADRIC arbitration rules. And what they provide is that any objection to the med-arbitrator on the basis of a reasonable apprehension of bias or justifiable doubts about the arbitrator's independence or impartiality must be raised. I think it's within 15 days of the party learning of the information. And that makes sure that parties don't sit on this argument and later raise it after the whole process has concluded. And here's another critical term. During the arbitration phase, the med-arbitrator must not use information from the mediation phase unless it becomes evidence in the arbitration or the parties consent to its use. So there's a clear provision that talks about the information that can be used after the mediation is concluded. If you have any questions about the Med-Arb rules, I'm going to say a few things, but you can put those in the Q&A box at the moment. I don't have any questions, but if you want to get ahead of me, now's the time to do it. So I have another issue which many of you may have thought about it. What do other institutions do? And I'm aware only of the ADRIC rules, certainly in the domestic context, which provides such a detailed regime that provides guidance on what the process should be. And there's no reason why those rules cannot be adopted in an international arbitration. The ICC rules, for example, provide mediation rules and arbitration rules, which the ICC says may be used together. The focus of those really is on multi-tier arbitration. But what these rules allow you to do, if the institution allows it, is to customize a process which could be based on the Med-Arb rules by ADRIC. There are a whole bunch of other variations which you may have heard of, and the limits are only your imagination. So I have heard of Med-Arb med processes, and you can imagine a situation in which the parties decide to move only certain issues through the process at a time. And an arbitrator may decide, after hearing submissions of the parties in the arbitration, that there's a possibility for a resolution that didn't seem possible in the earlier med phase, and the parties may wish to embark upon a further mediation stage before the arbitrator renders a decision. That's an option. Again, it'll have to be recorded in writing to protect the process. There may be a process that parties want in which there are different individuals who play the role of mediator and arbitrator. The process proceeds in the same way, but the mediator arbitrator is not the same person. And there may be an opt-out process that I've heard about, where another arbitrator steps in for the arbitration process if either party has concerns about the independence or impartiality of the person who's proceeded with the mediation. And what that means is it doesn't require the whole process to start again, but it allows for the timetable and the process that the parties agreed to as a Med-Arb, but the arbitrator is now substituted. So that's all I have to say about Med-Arb. Lots to think about. Again, if you've got any questions, put them in the Q&A box. As I said, the next session is going to be April the 18th. I'm calling it Med-Arb Part 2, and I'm going to be interviewing David McCutcheon by Zoom. I'm going to post some information about his qualifications, which I think you'll find impressive. He was a member of the committee that drafted the Med-Arb rules, and so I think he will have a lot of insights from that process, as well as his experience in doing many Med-Arb processes. I'm going to ask him some questions about some of the practical issues that I can think of. And those who register for that session will receive his standard terms of reference. And I will be asking him some questions about that, and as well as some procedural questions. And if you have any questions that you would like me to ask him, or you would like to ask him, I will have the Q&A box open, and we'll spend about 45 minutes to an hour with David, allowing you to ask questions of him. I don't see any questions, so I'm going to close the session. It's 12:41. I hope you found this of interest. It's an issue that I am hearing about increasingly, and I think it is, as I say, another tool in the ADR toolkit that I think we're going to be finding parties and counsel are going to want to use more often than they have in the past. I can say that ADRIC does provide training in Med-Arb. If you go on the website, there is a course that I think is starting in early June, and it gives you the criteria and sets out the syllabus. And so if you are interested in learning more about this and getting some accreditation, please take a look at the ADRIC website. Have a great day. Bye.